Hey guys, this is attorney Philip Adams with the law offices of Philip Adams here in Shreveport, Louisiana, and I want to talk to you today about an interesting law. Specifically, this is a law on disturbing the peace through use of profane words under Louisiana Revised Statutes 14:103, Section A, subsection 2 of A. And let me read that statute so that you understand what it actually says. So the law says, disturbing the peace is the doing of any of the following in such a manner as would foreseeably disturb or alarm the public. 2, addressing any offensive, derisive, or annoying words to any other person who is lawfully in any street or other public place, or call him by any offensive or derisive name, or make any noise or exclamation in his presence and hearing with the intent to deride, offend, or annoy him, or to prevent him from pursuing his lawful business, occupation, or duty. Now, that's a lot of language, and it's quite broad in its scope and potential application. A law can be unconstitutional in two ways. Number one, a law can be unconstitutional on its face, meaning that it's unconstitutional in its entirety. Number two, a law can be unconstitutional as applied, meaning within the particular context of an individual's case. So maybe the law has potential application that can be construed as being constitutional, but on the other hand, in certain situations, has potential application that might not be construed as being constitutional. That would be an as applied challenge. Think of the word applied referring to a given circumstance. It'll make it easier if you don't understand how that's distinguished from a facial challenge to the constitutionality of a statute. Face meaning, the entirety of the statute. So let's consider a hypothetical fact pattern, because I think that if you look at this law, disturbing the peace through use of profane words, I think that it's unconstitutional in an as applied manner. And I'm going to illustrate why through an example. So suppose an individual says to a police officer, "You're an asshole." This individual doesn't scream these words or make a big public disturbance or anything like that. The individual just simply mutters those words to an officer under his or her breath. Now, these words are arguably very distasteful, and I can't imagine anybody enjoying hearing these words. But again, we're talking about a legal scenario. Let's assume that this individual tells his officer this, and he uses a normal tone of voice, and the officer hears. The officer then becomes enraged by what he perceives to be an affront to his authority, and he pulls out handcuffs, and he handcuffs this individual immediately for disturbing the peace through use of profane words under Louisiana Revised Statutes 14:103 A2. This person is transported to jail, spends some time in jail, eventually bonds out, and then finds out that he's going to be formally charged by the prosecutor under the same law that he was arrested under, and is now going to consider potentially challenging the constitutionality of this statute. Can he be validly prosecuted under this statute under these circumstances, assuming there are no other facts that are relevant? I think not. So if we look at what the law is, and we look at the Constitution, specifically the First Amendment, it guarantees freedom of speech and forbids states from punishing the use of words or language that isn't within very narrowly defined categories. If you look at a U.S. Supreme Court case law, it reads along the following lines: even as to such a class, however, because, quote, the line between speech unconditionally guaranteed and speech which may be legitimately regulated, suppressed, or punished is finally drawn, in every case the power to regulate must be so exercised as not, in attaining a permissible end, unduly to infringe the protected freedom. So, and that's coming from Cantwell versus Connecticut and Spicer versus Randall, two U.S. Supreme Court cases. So what does all that mean in layman's terms? Well, it boils down to a law can regulate speech and still not violate the First Amendment as long as it doesn't unduly infringe upon protected freedom. So that law cannot regulate protected speech. So the law has to be very carefully drawn to punish only unprotected speech and cannot be susceptible of applying to protected speech. Another case from the U.S. Supreme Court. Because First Amendment freedoms need breathing space to survive, government may regulate in the area only with narrow specificity. And this is coming from an NAACP case. So the government can regulate, quote, the lewd and obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury and tend to incite an immediate breach of the peace, end quote. This is from Chaplinsky versus New Hampshire, another U.S. Supreme Court case. So basically, the only words that by their very utterance would inflict injury or incite an immediate breach of the peace can be regulated under the First Amendment without violating someone's free speech rights. So are the words, "you're an asshole," simply muttered under one's breath, considered to be fighting words? I think not. So if we look at the case law, even in Louisiana, courts have ruled that police officers are expected to exercise more restraint than even ordinary individuals, and insulting language is less likely to cause a breach of the peace and fall within the fighting words exceptions to protected speech. One example that arose out of Louisiana, specifically New Orleans, would be through Lewis versus City of New Orleans, another U.S. Supreme Court case from 1974. If you're interested in looking further into that. So to cap things up, the disturbing the peace statute that criminalizes profane words in Louisiana, in my opinion, would be unconstitutional as applied within the context of this specific hypothetical in which an individual mutters under his or her breath, "you're an asshole," to a police officer, assuming no other facts exist in this hypothetical. While those words might be distasteful, the officer would be expected to basically tolerate that kind of speech and move on. An individual would have the right to curse an officer in that context. Now, if an individual, for instance, screamed those words out loud and started making a huge public disturbance, then arguably things might change and it might be constitutional as applied within that case to make an arrest. But again, every case has to be evaluated based on its unique circumstances. Take care.